Started. All right, ladies and gentlemen, thank you so much. Welcome to my humble abode. Thank you for fighting the LA traffic and the LA heat to get here. So I appreciate you guys coming. Please make sure to get food, get drinks. I don't want to take any of this home with me. I don't need the extra weight here. Dave Ma, I'm the vice chair of the corporate department here at Jeffer. Honored today to be joined by Brad and Eric, and I'll get to their bios in a little bit, but I want to emphasize that notwithstanding that our names and faces were on the invites, the real stars of this show are you guys, right? Because the whole purpose of this is we're going to give you guys information. What I really want to do, and I tell this to a lot of my clients, is talk to people and business owners who are not in your industry. Get out of your bubble. Talk to people, talk to them about their successes, talk to them about their challenges. I think what you'll find is even people who are in very disparate industries, right? We've got people from healthcare, manufacturing, entertainment, business services, very, very different types of businesses. But I think you're going to find there's a lot of interesting challenges and a lot of different ways to approach it. So please make sure to mingle both before. I know you guys were doing it before, but do it after as well. Okay, so let's do the bios. Brad is a principal and senior wealth advisor with Focus Partners Wealth, one of the largest national independent wealth and financial advisory firms in the country. Brad has 32 years of experience providing guidance to successful families and focuses today on helping entrepreneurs plan business exits and making their visions of their best life a reality. Love it. Great. Eric is the founder of Fluential Partners, a boutique investment bank that advises companies on M&A and capital raises. A lawyer originally before investment banking, Eric served in a wide range of executive roles, such as general counsel of Panavision and CEO of a technology startup. Because of his background, Fluential is one of the rare investment banks that helps companies prepare for a deal, often years in advance. Okay, so Brad, I think you're up first.
Great. Thanks, Dave. It's good to see you all here. We've got a nice full room, actually probably can accommodate anybody else. All right, so let me just get this up here. Dave, thank you for setting the stage. I think it was very good framing for our discussion today. We're going to share with you all some information that I hope would be very valuable for you, whether you are a business owner or a professional advising business owners. There's a lot to digest here, and there's a lot to think about if you are in the process of selling a business today, or maybe you're still early in the startup phase of a business. I think it's all really relevant. The background that I come from, as Dave mentioned, I've been in my field of wealth management for 32 years, but I've also been in your shoes as a business owner. I founded my own firm and ran that for about 20 years before that was acquired by the firm that I'm with now, which also happens to be owned by a private equity firm. So I've been through all of those experiences. And today, what I really love doing is having the opportunity to work with business owners and hear their story. How did you get to where you are today? And what are you thinking about for the future? And is there a vision of a life after this that I call your third act? What does that look like? And there's a lot of excitement around that. There's also a lot of challenge to deal with. And I want to share with you to start off, sort of setting the stage as to what's going on in the field of closely held businesses and their sales here in the United States. So the information I'm sharing with you is coming from an organization called the Exit Planning Institute, which I'm affiliated with. And this is a national organization for professionals that specialize in guiding their clients through exit planning transitions. On a regular basis, they do a survey of thousands of business owners throughout the country. And this information is coming from their national 2023 Business Owner Readiness Report. So what's interesting is that in the next 10 years, 73% of privately held companies are planning to transition. And of those, we know is that 57% of baby boomers are thinking about an exit, and 38% of Generation X business owners want to exit in the next 5 years. Now, for baby boomers, it's obviously very relevant to their age. Most baby boomers are now somewhere between their 70s and 80s, and they're thinking about what is going to happen with this business after me. Maybe it's time for me to start enjoying life if I haven't already been doing that. And maybe it's time for me to think about this business having a life beyond me. I see also a lot of Generation X business owners are saying, I don't want to be like my parents. My parents own their businesses, ran those businesses until their grave. I want to start enjoying life now. I want to start experiencing more. And so we see a lot of this playing out in the thoughts that people are having about their transitions. But unfortunately, about 50% of business transitions are not planned. They're involuntary. They're an accident. We'll talk about why. And the unfortunate reality is that most business owners are not happy with their decision. Within a year of selling, more than 75% profoundly reported regretting selling their business. 70 to 80% of businesses listed for sale actually never sell. So I'm going to talk about some of the reasons why we see these failures, lack of satisfaction for business sales. But first, we'll start off with the lack of planning exit result. What we know in the industry is that 50% of business sales come about involuntarily from what we call the 5 Ds: death, disability, divorce, distress of the business, or disagreement. So businesses are put up for sale because something bad happened. The business owner is unfortunately now in a position that they have to take an option that they were not planning to pursue, but life is throwing them in a situation where they're confronted with the reality that they must face, and they need to get out as quickly as possible. On the other hand, when is the right time to sell? So we think about it as the opportune point for a business owner to consider selling their business is the alignment of what we call 3 legs of a stool. There's the personal leg, there's the financial leg, and there's the business leg. The financial leg really relates to the business owner's financial situation. Most business owners think of selling because they're ready to walk away. They want to have a liquidity event that's going to allow them to pursue what I call their best life. Or they're ready to move on to the next business opportunity. Maybe it's not to retire, they want to move on and start the next gig. But in most cases, there's a certain amount of liquidity or wealth that they want to be able to extract from that business. So an opportune point was when they realized the business could provide that level of wealth for them, what we call the wealth gap. The second piece of it, and this is probably the most important one, that issue related to regret, is business owners in many cases have our identity tied up in our business. It's who we are. It's our life. I was actually having dinner last night with a client. We were celebrating our relationship together over 20 years. We were talking about what he and his wife enjoy doing, and they're very different in their positioning because she says, I want to travel more. I want to travel a lot more, but he hates traveling. He hates traveling, doesn't want to go on trips. And I said, well, what do you want to do? And he said, I want to work. I just want to work. And he said, when we go on trips, like we go on a cruise, at least I can stay in the room and work on the ship. So for him, that's his identity. It's also his, joie de vivre. It's why he's existing. But for a lot of people, it's a crisis of conscience, of confidence, of identity, of who they're going to be if they're not who they are today. So in my work, we spend a lot of time with business owners early on in the process, really addressing that question. If you're not this anymore, if you're not the CEO or founder of this company, who are you going to be? What could you derive meaning and value from? Could you start another business if that would, kind of float your boat? Could you be actually involved as a passive investor in private equity or venture capital opportunities where you could get to know those businesses but not have to run anything? Could you be involved in philanthropy and donate your time or your resources financially towards causes that are important to you? Maybe it's the leisure life of traveling in country clubs, but for a lot of people that were busy, working, successful people, that gets stale pretty quickly. That's where the regret comes in because they're told you should enjoy your life. And they're sitting there thinking, this is terrible. Why did I do this? I'm a fool. So that's a really important issue, making sure that we can identify what that identity replacement is going to look like, what they're going to derive purpose from, and also addressing any other goals that they might have in life that they want to address. The last piece of it is the business leg. This is when the business is ready for that owner to walk away. Now, that might mean it's a transition internally to the next generation of family members where there's an identified succession plan internally, or simply it might mean that the business value has been maximized at this point. And that would be the ideal time for them to be able to walk away. So we can have an alignment of these 3 legs of a stool. That's the perfect time for that business owner to be able to sell. We also think about it in terms of what we call the 3 gaps. I was already talking about the last gap here, and that's the wealth gap. But we get to that actually from backing into the other 2. It really starts with what we call the profit gap. And this really comes from an understanding of where a business is today in terms of its profitability, and how does that business fall in the range of best in class to not so good. So if you're a best-in-class business and you're operating at maximum capacity of profit, there is no profit gap. But if we look at your business and do a real honest assessment, figure out that your business could be worth, let's say 20% more, 50% more, if you close the gap in profit from what you could be making if you were running optimally, that's the first step. What would closing that profit gap equate to in terms of increasing the value of the business? Because that increase in profit or EBITDA is going to translate into a multiple of value, which becomes that value gap that can be closed by making that business run at an optimal scale. That then addresses the potential wealth gap. If the business can be sold for a higher value, that's going to mean more money in my pocket to be able to create my lifestyle needs. When we work with clients, we have very different engagements. So as Dave and I mentioned, I'm in the field of wealth management, but a lot of my work really is related to helping business owners plan their exit. And the engagement has nothing to do with management of money or investments. It really has to do with having a consulting relationship that ideally starts years in advance. And the ideal time really is in the early stages of a business growth life, because that's where we can have the most impact on professionalizing that business, not only through our guidance, but through a team of experts like corporate attorneys and investment bankers, business process optimizers, HR professionals, accounting individuals, where we can really have the most impact. But it really starts with stage one is about identifying the value. What's your goal for this business? What do you want to try to achieve? And then we look at an assessment process that begins with fact finding, understanding everything that we need to know about that business, everything you need to know about the financials, the structure, the organizational management, the employee composition, what's the culture like, what is the documentation of the processes, what are the manuals, everything that needs to be known about that business we'll identify. And then we'll provide to that business owner about a 20 to 25 page report or assessment, grading them in every single area. So that's going to help us understand where they are in the range of value. For example, if it is a healthcare business of some sort, how does your business fall in the range of value versus best-in-class businesses? And where do you fall short? That would create for us the areas of opportunity that we can work on. If we've got 5 years or more, we're going to put together an action plan to execute on a quarter-by-quarter basis to try to identify where the gaps are and close those gaps. The second process is about protecting value. So protecting value for the individual business owner is about financial planning. What do we need to address to create a roadmap for them to connect the dots between their financial resources and the goals that they have for their life? And how do we also protect against unplanned events for them personally, or unplanned events for the business that could be disastrous? And then we're going to work on action steps to help de-risk that business. Stage 3 is about maximizing the value. It's about understanding the potential options for exit, strategic planning to figure out how we can capitalize on opportunities to improve the value of the business through better structure. We're going to look at all the financials and really understand what is the true profitability of this business. Because, as you know, being business owners, most business owners rightly would try to minimize their taxable income from the business and just run as much as you could of personal expenses through the business that you can get past the IRS. But from a sales standpoint, you don't want to do that. We really need to add back all of those additional perks, as you might call it, to really understand what the true financial position of the business is. We want to learn what the systems and procedures are in place and try to optimize those. We're going to look at marketing and sales and see how effective that is. We're going to understand the corporate governance today or lack thereof. We want to understand the mindset of the owner and how maybe that's going to translate to the next generation if there is a possible succession plan, or how the employees view that ownership mindset. So it'll give me a series of several steps to try to maximize the value. Now, if we have a year to try to plan for an exit, that's not really going to be possible. There's very little opportunity to try to create additional value if you're getting ready to put your business up for sale. Okay? So the more time we have, the more we have an opportunity to create some additional improvement there. And I would say probably 3 years minimum is the right amount of time to be able to extract that additional value. Stage 4 actually gets to extracting that value. Now it's ready to, we're at the point we're ready to actually do some tax planning, because it's not just important to look at what you can take out of the business as a sale price, but what can you keep after taxes are taken into consideration. So, and that usually takes, I would say, 3 years is an ideal amount of time. 5 years is even better, Because one thing that's going to be looked at, which Dave will talk about in a few minutes, is how does your tax corporate structure relate to your opportunities for tax reduction? For example, qualified small business stock and how that can be giving you a capital gains exemption if you're a C corporation. Well, if you're not, you don't get that. So tax planning is going to be really important, documenting the business and its value, and then preparing for the liquidity event. And then beyond that, stage 5 is about managing and protecting the wealth of that business owner for the rest of their life after the business sale. So there's a lot that goes into this process. The more time we have, the more value that can be created over time, and the more successful that'll be. Now, our firm, Focused Partners, plays a really important role in the lives of our clients, because beyond that business liquidity event, that's not the end of the relationship. That's really just the beginning. It just transitions to something different. So now we're not helping them exit the business. We're now helping them manage their life, every facet of their financial lives. And as I explain it to our clients, it's really about becoming what we call your personal CFO. Or in the professional world, we would say your family office manager. It's about connecting everything together. It's about helping with budgeting and cash flow planning. For some of our clients, we'll do all that for them. We'll pay all their bills. We'll do all of their family bookkeeping. We're going to help, of course, with their investment portfolio. We're going to help with their tax planning. Sometimes we're going to do tax preparation as well. We're going to help them with legacy planning, creating their estate plan, updating their estate plan, talking about philanthropic goals and helping them execute those philanthropic goals. Of course, looking at risk and helping to protect against risk in terms of insurance or ownership of assets through various structures. All of these things get coordinated into a holistic approach, and not only through us, but the team that we can create of external professionals to provide all those necessary resources. That's what we do. So as a firm, we have offices all over the country. Actually have 100 offices. We manage about 200 billion of assets today, from clients that are wealthy up to the extreme wealthy. And we have a team of over 2,000 professionals that come from different areas of expertise. So we can really bring to the table all the kind of guidance and resources that our clients need. So with that, I'm going to stop here, and Dave, I'm going to turn it over to you to come up and talk about corporate structure and the work that we do.
Cool, thank you. So one thing I forgot to mention is that we're gonna have a Q&A session after all this. So, but if you have questions, feel free to ask. I'd love to make it kind of interactive, okay? So what I want to talk about are the things that you can be doing at different stages of the timeline of your ownership of your business, and some things that you can think about, right? Because we have folks here in the office who are at various different stages. We have folks who have basically a startup, just kind of got things started, and they've got maybe 10 years, maybe they got more time than that before they can have some sort of sales event. We have people in this room, including some of my own clients, who we are currently in a sales process, right? So we have this whole wide range. What I want to do is kind of break it up into 3 different phases and talk about just a handful of things that you can be thinking about during that particular phase that will set you up for success down the road. I'm not saying you have to do all these things, and even if you didn't do some of these things, that's okay. We can try to, fix some of the things as we go through the process. But the more that you can think about your final exit, the smoother the ultimate process is, and the more likely it gets done, right? So it wouldn't be a lawyer if I didn't have a disclaimer. Please, everybody read it and acknowledge it. Okay, cool, accepted. Roadmap. All right, there's 3 phases I'm going to talk about during this presentation. We got 3 to 5 plus years from now. We got 1 to 3 years, and then less than a year. And really, less than a year, we're talking about deal execution. I mean, it's baked. We're trying to exit. Let's get this thing done. So 3 to 5 years. Why do I think about 3 to 5 years? 3 to 5 years is because most buyers, when they're doing diligence on you, are going to ask for roughly 3 to 5 years of financials, records. You'll see for any of those gone through rep and warranty, they'll typically say, oh, in the last 5 years, you haven't been sued, et cetera, right? So 3 to 5 years is a good time to start thinking about, these are the types of things I'm going to have to disclose to a potential buyer. These are the labor and employment issues I had. There are the infringement issues that I had to deal with, right? So about 3 to 5 years is when people start looking at things. A couple things, and I won't go through all of these in detail because I think we'll be here all night, but just a couple of things to think about. So entity structure. It's critical that if you are considering QSBS, qualified small business stock, which is basically a mechanism that allows you to exclude the greater of $10 million or 10x your basis, each shareholder in a C Corp can do that, right? But there's a specific holding pattern you have to have. You have to have at least under the new Big Beautiful Bill Act, they actually get it 4 years to get some benefits, but really it's 5 years. You got to hold it for at least 5 years. If you don't get that, you're not going to really maximize your benefits. So what that means is if you are not currently a C Corp and you're considering it and you have an exit maybe 5 years from now, you really got to start the clock today on that holding period. Because, I'm working on a transaction right now. We're about a year, they have about 4 years left on their holding period. They have about 1 year left. So they've held it for 4 years. And we're in this kind of awkward situation where we've got a potential buyer. It's a good offer. It's a very solid offer. But if they wait about a year, they're going to save a lot on taxes. We're talking possibly $50 to $60 million of gain that they can exclude. And they're kind of in this awkward, I wouldn't call it a rock and a hard place, but it's in an awkward situation where it's, do we take the offer that we have on hand and just pay our taxes? Or do we kind of roll the dice, hold it for another approximately a year and hope that we can get that buyer still there, or we can find a comparable buyer? So we're actually trying to help them go through some of these decision trees right now. But that's because they didn't convert to a C Corp until 4 years ago. Other things to think about: get your cap table straightened up. We have some clients of mine who, they've made promises on the back of napkins. There's a lot of handshake deals. Let's get that cleaned up. Get it cleaned up now, because what you don't want to do is you're, a year out from closing, and then you go to your minority investor and say, hey, can we finally button this thing up, right? Well, now they got a little bit of leverage on you if they know that you're looking to exit relatively soon, and maybe all of a sudden things that you agreed to, they kind of forgot about. So let's get that buttoned up now before there's a deal even on the table, so that way people don't have the wrong incentives. Buy-sell agreements. So anybody with an S Corp here really needs to have a buy-sell shareholders agreement. As you probably know, if you have an S Corp, there's very limited numbers of qualified small business, the S Corp holders, right? You have to be an individual or certain trust. If you don't have some sort of shareholders agreement in place that says nobody can transfer their shares to a non-eligible S Corp holder, somebody could have done that. Somebody could have done it inadvertently, right? Where they move it into a trust and they didn't tell their trust and estate attorney that, by the way, this is an S Corp. Let's think about whether or not this trust can actually hold it. You may have already inadvertently busted your S Corp election. And if you do that, you may not know this for years, right? We had a client of ours, didn't know it. They busted it for 3 years. What does that mean? You have to go back and amend your tax returns for 3 years, right? It's a lot of extra work to go through. So get yourself a shareholders agreement and get that updated, right? Think of it as almost like an estate plan for your business. If something big happens in your business, consider updating or having somebody just take a quick refresher of what does our shareholders agreement say, right? Do we have a buyout provision? If somebody's looking to retire, do we get the automatic right to buy them out, or do they just keep all their stock, and all of a sudden I have 30-40% of my cap table that's just retired in Tahiti, and I'm doing 100% of the work for 60% of the profit, right? So think about those sorts of things. The right sort of documentation when you're starting out may not be the right documentation once you're a little bit more mature, and certainly not when you're getting ready to exit. Other things to think about are things like drag along provisions, right? If you don't have a drag along provision, a drag along provision basically says if a certain percentage, typically 50% or more, decide to sell, everybody's got to go along. We can't have a 3% holder saying, I'm going to hold out for a little bit more money, right? So if you don't have those things in place, again, consider putting them in now before there's a deal on the table, so nobody can play gamesmanship here, right? 3 to 5 years out, think about your existing customer contracts, right? Your vendor contracts. Do you have contracts in place? I did a deal recently. It closed earlier this year. It was a very significant business. When the buyer came to us and said, hey, give us all of your material customer contracts. And he said, this is my material customer contract. I shake hands with everybody. That's it. That's it. He has no contracts at all for 45 odd years. And that could be a problem, right? If you have the wrong type of business, what a buyer wants to do is they want to buy your business. And if you get hit by a bus the next day, it's okay. They can keep running the business, right? If everything is up here and everything is a business relationship, that makes your business hard to sell, right? So in this particular case, they have a great business. They've been just really strong. And then what's happening is the owner is going to stay on for a significant period of time to transition the business. He would love not to do that, but that was a condition of the buyer because all the relationships are with the person, right? So get things on paper. That's nice. Know what the terms of your contracts are. So even if you can't change the terms, it's good to know at least what's kind of out there, right? If you have if one of your major distributors has a anti-change of control provision that says if you change your control, they can go and terminate the agreement and renegotiate the deal. All right, so be it. Maybe that's what you had to agree to get the deal done, but be aware of it so that when we're getting ready to go to market, we can proactively think about how we want to approach that distributor, that counterparty, and renegotiate or get some sort of assurances that they're not going to hold up the deal, right? Because the last thing you want to do is get ready to sell, and then it turns out your biggest customer says, "Oh, maybe this is a great opportunity for me to get some better price and terms," right? Document everything. Again, verbal contracts, very messy. People forget things. Legal due diligence. What are some low-hanging fruit that you can start doing now to kind of save yourself headaches? Lien and litigation searches. If you've got a business, there's people sue you and you don't know it. You don't get served, right? Or maybe there's a tax lien somewhere in a state that you haven't thought about, right? Let us do a lien and litigation search. It costs you a couple bucks. We're going to do a very quick search. It'll tell you on a nationwide, here's what popped up, right? I've had so many clients, oh, I got a $100 tax lien in South Carolina. Let me just go get that taken care of, right? Clean up your books now so you don't have to worry about it later. IP, if you've got IP, did you trademark your company name, right? Those are some low-hanging fruit. Doesn't cost you a lot of money, and it creates a little bit of a moat around your business, right? Buyers love seeing registered IP because it means that you've spent some time protecting your IP, developing your IP. Employee handbooks, I think everybody here is from California or has a business in California. If you've got employees, get your employee handbook reviewed every single year. The law is constantly changing. A couple of years ago, we were saying, don't do arbitration agreements. There's X, Y, and Z, why it's not good for you. Now we're telling everybody, do arbitration agreements with all of your employees, right? So the law can change. And sometimes the rest and meal period stuff changes. You've got to get that stuff updated, right? Big ticket items. And I won't say who in the room, but we've had certain clients here who've had to deal with W-2 versus 1099, right? That's, especially in California, that's a very common issue. We love doing 1099s, but it's not always permitted. So keep that in mind. There are specific ways that we can kind of solve these problems, but they got to get solved earlier rather than later. Again, the longer you just let it kind of fester, the greater your liability tail is, right? Sales tax nexus. Think about if a lot of people here have businesses that have customers all over the country, right? You may have sales tax obligations that you have to pay. So again, let's get that taken care of now. And then lastly, litigation. If you've got a significant piece of litigation, you're still batting around. Maybe this is about when you want to start trying to figure out a way to get rid of it, right? Whether that's a settlement or get a little bit more aggressive. Because again, the more that we can clean up now, where we're 3 to 5 years out, we don't have to disclose it, or we can disclose it with hey, we settled this issue 3 years ago. Let's not worry about it, right? Okay, 1 to 3 years. We're getting a little bit closer. Now we know, I'm thinking of selling in a couple years. What should we be thinking about? This is when you start engaging in seriousness. I mean, look, we'd love to all get engaged. I love to get engaged, the day the company is formed, but that's not super realistic. A lot of people are not looking to hire an M&A lawyer the day that they form their business, as much as I would love them to. But this is really, we got to start thinking in real seriousness, right? We got to get everybody buttoned up, get our advisors in place, right? Execute on your process, position yourself for maximum value. Who is the advisor team? I always think of it as four different groups you want to have, right? You want to have your M&A attorney, very selfish of me. I put myself first, right? Hire an M&A attorney. Investment banker, great. Hire Eric. Wealth advisor, hire Brad. Fourth one, we didn't have him for this meeting, but maybe we should have, is a CPA. And I'm talking about a CPA who specializes and has experience in M&A transactions. Your day-to-day, bookkeeper or your tax preparer can still stay involved, and typically we'll want them to stay involved. They'll help us prepare your financials, they'll help us gather information, they'll help us with disclosure schedules and things like that. But are they the right CPA who can negotiate working capital, EBITDA, all sorts of other kind of higher level stuff? And you'd want to have somebody in your corner who's been through this every single day. This is all they do, and they're really experienced, right? So again, we're not looking.
The health advisor.
And the health advisor, right?
You don't want to.
If you don't make it to the finish line, nothing matters, right?
Yeah.
Thank you. I'll add that to the bullet points. VDR, your virtual data room. So you want to start thinking about and gathering all of your documents, right? Get all of your customer contracts. I had a client of mine years ago who did not digitize anything. Everything was just, but we said, great, bring us all we'll send a junior associate, pick up boxes of your contracts, We'll bring them into our office, we'll scan it, digitize it, right? Because what you don't want to do is you're getting ready to go to market. They're great, upload all your contracts. It goes, well, they're in a storage unit over here, right? That's going to slow things down. You don't want to slow things down. Once you're down on the road for the process, you want to go, 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 go. Okay, less than a year out. It's execution time, right? What's done is done. Let's get it done. I always tell my clients, it's not a marathon, not a sprint. It's both. You're going to run a marathon and a sprint race, okay? We're running, we're booking, all right? Because on a long enough timeline, every single transaction fails, right? If you wait too long, something slows you down. It will always fail on a long enough timeline. Okay, this one I put as a slide on its own. This is super important. An LOI is not just a term sheet. There have been many times where I get engaged by a client who says, I just signed the LOI, I'm ready to hire an M&A lawyer. And I said, I don't like that at all, right? Look, it's a non-binding document, I agree, but this is the framework for the transaction. So if you didn't ask for something in the LOI stage, good luck convincing a buyer that they should give it to you later just because you hired a lawyer after the LOI got signed, right? The way you want to think about it is, you want to think about leverage on a timeline. So your leverage as a seller is at its peak maximum when you're getting ready to pick which buyer you want to go exclusive with, right? And the buyers typically, as long as it's a competitive process, and Eric will be making a competitive process, you've got a couple of different buyers that you're kind of playing off each other. This is at their lowest leverage. So if you want something, you want to ask for it then, right? Because you can kind of pick the buyers off of each other. The moment you sign exclusivity with an LOI, your leverage goes to zero. You're kind of baked, right? Because we've probably many of us have bought homes before. If you see a house go, into escrow and then out of escrow, you don't want to buy it anymore, right? What happened, right? Did it fail an inspection? Were these difficult sellers, right? Like you don't know. Your leverage is much, much lower if you go into exclusivity with somebody and things don't work out and you go back to the market. It's very difficult. It's very difficult. Okay. I want to just talk about a couple technical points about purchase agreements. I won't get really lost in the weeds on stuff, but think about things like purchase price and structure, right? So there's a couple different categories of purchase price. Cash is king. We love cash. Cash is great. Earnouts, don't love earnouts, but sometimes you need earnouts to close the gap, right? You think your business is here, the best offer is here, we'll do an earnout. We'll figure it out, right? Who's going to be right? Who's going to be wrong? There's always risk because now you're giving up the keys to your business. Someone else is running it. And are they going to try to hit your earnout? Maybe, maybe not, right? Maybe not. But if you need to close the gap, this is the best we got. Rollover equity. If you're getting acquired by a private equity firm, generally speaking, you're looking to roll probably anywhere between 35–15% of your ownership into their platform. Some sellers love it. They love it because they're great. I get a second bite at the apple. I got a bunch of Harvard MBAs managing my money, and hopefully in 4 or 5 years, we're going to exit and make even more money out of this, right? Some people don't like it. Some people say, look, I want to take my cash. I want to buy real estate. I want to invest in public securities. I don't want it to be trapped in this private equity fund that I don't control, right? There's no right or wrong answer, but you should think about how your rollover equity will be treated on a final exit. So some things I always do is I always want us to be pari passu with the private equity investor, right? Every once in a while, you get a private equity buyer who wants to be some sort of preferred interest, and you have a comment. No, you don't want that. You want what's good for the goose is good for the gander, which means you want to be pari passu with the private equity guys. And we'll go through all of these things. Exclusivity. So this is really important. Typically, a LOI is non-binding other than the exclusivity period. So once you go to exclusive, you're kind of stuck with them, right? And they call this no shops. It basically means you can't talk to anybody for that period of time, and you're kind of stuck with them. They're not stuck with you. They could choose to no longer pursue the process, but you're kind of stuck with them for that period of time. And then, some purchase agreement key provisions. So reps and warranties. I've been talking about reps and warranties. These are promises you make about your business, right? I haven't been sued. I've paid all my taxes, right? These are really important. Covenants are things you either will do or will not do following the closing. The most common covenant would be something like a non-compete, right? I agree not to enter into this business line for 5 years post-closing. Closing conditions. Certain people, if you're lucky enough to sell your business for hundreds of millions of dollars or more, you have to go through antitrust and all sorts of other regulatory approvals. So think about how that's going to impact your transaction, right? Here's one thing I want to highlight for many of you who are thinking of selling your businesses. someone's gonna at one point talk about rep and warranty insurance. I hope so, right? If you hire a lawyer, they don't talk about it, then get a new lawyer. Rep and warranty insurance is this relatively new insurance product that basically has a third-party insurance company insure the risk that the seller breaches their reps and warranties. So let's say you made a rep to the buyer saying, there's no threatened lawsuits against me, right? I don't know any threatened lawsuits. Turns out you're wrong. You forgot that one of your employees said, you discriminated against me. I will file a lawsuit against you later. And post-closing, they file that lawsuit and they find a paper trail saying, yeah, this employee made these threats. You didn't disclose it on your disclosure schedules. Therefore, you breached your reps and warranties. If we were doing this deal maybe 10 or 15 years ago, you do an escrow. You basically escrow a portion of the purchase price. And if there's a claim made post-closing and you lose, the money comes out of escrow. That also means that you've tied up 8 to 12% of the purchase price of this non-interest bearing account for 12 to 24 months, depending on the deal, right? That's a lot of opportunity cost. So you could have taken that money and done something else. Rep and warranty insurance is basically this third-party insurance product that says, hey, if you breach your reps, the insurance company will pay out. The buyer deals with it with the insurance company. You don't have any liability. You just walk away. We literally call it a walk-away deal. These are fantastic. You can negotiate a full walk-away deal. Take it every single time. That's better than I will give up a little bit of purchase price for it, right? So that's all I got. All right. If you have any other questions, we're gonna do a little bit of a Q&A, and then Eric, tell us more about execution. Yes, that's a good question. So we will go and share these PowerPoint slides to everybody that came, and then that way you guys can read it because it's so riveting.
Is that the clicker right there?
Yes, there's the clicker.
Okay. Thanks, Dave. So we're the investment bankers in the deal. If you don't know what that means, we essentially run the deal from a business perspective. We help prepare all the materials. We identify the right buyers. We go all out to all the buyers, and then we handle the negotiation. We run the diligence, and we get it over the finish line. Unlike my two wonderful colleagues, we get paid primarily on contingency, success fee. So we use incentives to try to get deals over the finish line. And incidentally, Brad mentioned that he had been a business owner. I did the opposite. Most sane people start in investment banking and then worked their way into companies. I actually started in companies. I ran a startup and I sold it, hired an investment banker. And when times got tough, they disappeared on me. I'd raised all the money myself. So I basically dragged the deal over the finish line. And when I was done, I said, I think I should just be doing this. So my slides are way too, luckily they're way too small for you to read, but you'll get them afterwards. But so when we are lucky enough to be engaged early on, we basically run a process that involves, first question is to the client, what are your needs? What are your objectives? Usually they want to exit. Beyond that, it's really an exercise of putting ourselves in the seat of a potential buyer. And we literally would think, okay, who's going to buy this business? Why are they going to buy it? And why wouldn't they buy it? And we look at that in great detail, and then we try to essentially align the company with the buyer objectives and address the objections. And if you're lucky enough to be engaged years ahead of time, as we have in some instances, you really can make a huge difference, not only in terms of the price, but whether there will be buyers at all. So from a high level, there's two main kinds of buyers. There's strategic, or companies, and there's financial, which are primarily private equity funds. And you're not gonna be able to see this, but they differ as to how they approach deals, how they value deals, and what it's like after a deal with them. So just to bring up a couple points, one is that by definition, a strategic buyer has objectives other than pure financial return on the money they're paying. It could be that it's a company that's primarily international. They want to enter the US market. They're East Coast, they want to be in the West Coast. They're not in healthcare and they want to be in healthcare. They covet your clients. They want your talent. There's some reason why they want to go after the deal other than just purely financial return. Whereas financial buyers, it's very much spreadsheet driven. They have what's called an LBO model. They have young, smart people running their spreadsheets, and it's purely a numbers game for them. Interestingly, typically a strategic buyer will pay 25 to 30% higher than a financial buyer. So you say, all right, well, why don't you just go after the strategic buyers? The answer is that there's tons of reasons why strategics just don't do deals. They can say, you know what, we had a bad year, we're not doing any deals this year. We just fired our CFO. There's hundreds of reasons. Many of them have nothing to do with our clients. Private equity buyers, they have to get their deals done year in, year out. And they might get 5 to 25 deals done a year. So the private equity buyers kind of form the drumbeat of the process. We know the right ones to go to. We essentially know every private equity fund worth knowing in the United States and abroad. And we know which ones are going to bid. We also know roughly what they're going to bid. And then you take some long shots with the strategic buyers. Plus, we try to maximize the optionality for our clients. You never quite know what you want until you see what the different options are. So when we run a process, the objective is try to get as many different options as possible and let them decide that. Because not only does it impact price, but like afterwards, for example, strategic is typically going to eat your company, it's going to integrate it. If you built your baby, maybe the name is no longer there, maybe half the employees are gone, and you basically are swallowed up. Versus private equity wants to back a strong management team. They want you to stick around. And the kind of quid pro quo there is they will give you a second bite of the apple. Typically, you retain some equity, and at the end of the process, you could sometimes that remaining equity is worth as much or more than the equity you had that you sold to them originally. So, and then the other point essentially there is that you have to stick around with private equity, and you may be able to sell off in the sunset. So you really want to go for both. And what we do, this is just an example that we did for a client, is that we'll identify, and this is a small set, but we might identify several dozen buyers. And we say, here's why we think they'll buy you, and here's why they might not buy you. And that's what we try to align. So you'll get a copy of this to get an idea. So in terms of meeting their objectives and addressing their objections, here's just some examples of it, and I'll just highlight a couple. And by the way, fixing some of this is hard, and that's why you need to start 5 years ahead. So one of them is, like, whether you're strategic or financial, you want a healthy, growing industry. Right? Now, these days, that's particularly important because, as we know, with AI, there are a lot of traditionally very stable industries that are in mortal peril right now. They might not be around in 5 years. And that includes marketing services, a lot of professional services, tons of other businesses. So you have to think about that. And if your business is in moral peril, you got to think of how you adjust. Right? Another big one is EBITDA margin. So are you as profitable, and Brad mentioned this, are you as profitable as peers? Because if you're not, it impacts two things: size, talk about that in a second, and just the value you're going to get for it. So, and you could figure out benchmarks. That company in our industry usually has a 16% EBITDA margin, and wow, ours is 9%. How do we address that? I will tell you that most companies have more kind of expense at the corporate level than they actually need. They think they need it, but with the help of advisors, they realize that there is some additional profit margin that they can definitely squeeze out of it. Another is technology and IP and AI strategy, which I'm going to talk about in a second, becomes critically important. In terms of buyer objectives, here's some examples. Size, we're going to talk about in a second. Customer concentration. If over 20% of your revenue is derived from one customer, a lot of buyers simply won't look at you. It's not a question of valuation. They simply won't buy it. So it takes some years to adjust to that, but that's something you need to be keenly aware of because that's just a showstopper for a lot of them. So, and the others we could talk at great length, but I'm going to drill down on a couple. So size matters, as they said. And the reason is this, that there are tiers that the best buyers have strict investment criteria and they stick with it. And a main one for most of them is EBITDA. Below 5 million, you just lose a lot of buyers. Below 3 million, you're losing 80% of them. Below 2 million, you're losing almost all of them. So we actually don't typically take on clients with less than 3 million of EBITDA because we're just going to be turned down. And it's for good reason. Whether you're a strategic or a financial buyer, basically, if you have a bunch of choices among companies to acquire, are you going to spend time on the $2.5 million EBITDA business or the $25 million EBITDA business? No matter how good we are at our job, we're not going to talk them into altering their priorities that greatly. Then in terms of the revenue mix, it's an interesting one. And this is something we addressed with the client, who I won't name because they may be in this room. But buyers will value different kinds of revenue differently. The top is generally recurring revenue. subscription, right? The reason, it's predictable, it's repeatable. You don't have to go win it with every single customer. At the bottom is project-based. There's some buyers that simply won't look at a project-based business. There are plenty who will, but you may lose 30% that way. Among projects, you're better off with many small projects rather than a few large ones. It's just their risk concentration is that it's just too much risk for a buyer that they lose one customer and the business ends up being a loss. So now everybody loves this slide because everybody wants to know, what's my business really worth? So what this is basically EBITDA multiples by industry by size. What you'll see is in the smallest tier, which is under 3 million, it's about half the multiple of what it would be at 5 to 10 million. If you go up then from 10 to 25, it's only about a 15% increase over that level. So you see, really reaching a threshold of hopefully 5 million of EBITDA is critically important. And if you can't do it, you're just gonna, it's not to say you can't sell the business, but you're gonna have a much more limited pool of buyers and also, frankly, of advisors. And you know, a lot of the business we handle between 5 and 15, for those, we can find generally plenty of buyers if it's a fairly healthy industry and a company that's doing reasonably well. So this is kind of our 5, 3, and 1 year plan. I'm not going to go through every one, but 5 years out, you're identifying your likely buyers and you're starting to address the hard stuff, your business model. Like, are you too concentrated in an industry that might not be around or is in decline? In which case you might want to try to pivot to be in something like healthcare, which is frankly always booming, and I think will be for the foreseeable future. As well as like addressing your IP, things like that. 3 years to go, you actually want to start meeting your potential buyers. And here's the reason. It is much easier from our perspective if we go to a buyer and say, hey, this company's for sale. And they say, oh yeah, we know those guys and we've been interested in them for years. We were waiting for you to call, right? The way you do that is you just start meeting the CEOs or senior executives of the buyers, and you just have dinner with them. You say, hey, I want to hear your strategy and I just want to tell you ours, and let's stay in touch. You're not for sale. You're not asking for anything. You're just staying in touch. It is immensely helpful and well worth it, and not something that a lot of companies do. And then beyond that, 3 years out, you also want to start restructuring customer contracts in some of the ways that Dave mentioned. Not only things like change of control, but the length. You might, for example, want a client to pay less early on for a longer term contract because longer term contracts are more value and easier for us to sell. You want to really have a sharp focus on EBITDA maximization. You want to really dig in. By the way, Brad's firm is really exceptional in the amount of true kind of optimization that they do. It's rare for wealth managers, and you want that kind of help. We do it from a deal perspective, but you also want kind of the operational help to really figure out how do you squeeze the profit out of this business that it really has the potential to meet. You want to get your GAAP accounting straightened out 3 years ahead of time. A lot of companies, if you just file a tax return, there's really no reason to have GAAP financials, and you need them to be sold. You don't necessarily need an audit, but you need your financials really to be in good shape. So 3 years out, start taking care of that. You could also trim down things like what we call owner's discretionary items. Every business has them. Every private business has them. You got a car, a company car. Maybe you take some trips where it's half business and half leisure. There's just things where if it were owned by an institutional buyer, they wouldn't do it. Start trimming them down, because that way, like, we do an adjustment to add back those expenses, but much easier if you don't have to add them. And I will tell you, because sometimes we have clients who are very aggressive in their tax treatment, it doesn't look good. And the reason is that the buyer is saying in the back of their head, if they're not fully honest on their taxes, are they going to be fully honest with us? So again, it's not to say you don't put something on the business, but you want it to be something that is defensible, and then you want to really start trimming it down as you get closer and closer to the deal. I want to, and then 1 year out, you want to start really getting your financials, something called a quality of earnings report that an accounting firm will do. It's kind of in lieu of an audit, and you want to hire your advisors. I want to talk quickly about two other things. Technology. We were given this talk a year ago would have been much different talk. But with AI on the horizon, you need to have a technology strategy. The ones who are really good at having a technology strategy will be worth buying for that reason alone. And the ones that don't have a strategy, they might not find any buyers at all. So really start thinking of it. You don't have to be your own AI company. That's way too much. But you have to try to be best in class. Use the tools well. Know what tools are out there. Start experimenting. Start using them judiciously. Try to be, when they look at you, they say, all right, those guys are at least an A- in that regard. And then the interesting thing is there's some very kind of cool tools coming out there. We've developed one with a company that we call the Founder's Brain. So we'll actually do interviews and review documents and even get into emails of the founders and develop an LLM that represents the founder's brain. So that's two things. That means two things. One is when we sell the company, we could say, hey, private equity fund, here's a great company. And by the way, here's everything the founder knows in a form that you can ask questions of in case they are unmotivated or get hit by a bus or retire early. It's very cool. Every buyer we've talked about, their eyes light up. And the other thing is you just surface inevitably inefficiencies in areas that can be fixed. And so that gives you yet another opportunity to optimize. So there's going to be a lot of cool tools that come along. We're trying to be like top 1% in our use of technology. And, it's important because our industry is evolving as well. And then I won't go over this, but, the key, as Dave said, to a successful process is a competitive dynamic. So our whole objective is bring a lot of different options, create a competitive dynamic, and use it to our clients' best advantage. And Dave was 100% right. The maximum advantage is when you have multiple buyers that are all motivated, bidding, and you haven't yet signed an LOI. So it's a fun process. There's tons of ups and downs. There's a lot of problem solving involved, and it's something we enjoy. Hopefully it's been helpful. I think I'm going to wrap it up and we'll open it up to questions.
Awesome. Here's our podium. Podium here. Let's move some chairs and then, so we'll do a Q&A. I don't know how long this will go for. If you've got questions, I think this is the right time. This is really tall. What I always say is, my billing rate is very expensive. So this is where you get to give free legal advice. I'm not going to bill you for it, even if you're my client. So you won't see this on the bill. So please ask.
Put that disclaimer back on.
Yeah, put the disclaimer back on. So if you've got questions, this is the great time to do it. We've got a lot of folks, both business owners, advisors in the room. So if you don't have any questions, I've got some softballs.
One thing, Eric, that you shared with me that really stuck with me is that in a deal process that the deal dies 5 or 6 times. And I think it's just such a good mental prep for everyone to hear because that's stressful. And if you're not planning for it, it's hard to survive that.
Yeah, that's a great point. We do have a phrase, every deal dies 5 deaths. Deals are hard. It's why you need a good group of folks who have been through 50 or 100 deals, and inevitably there are problems. So one of our roles is we actually try to keep our clients calm. We've seen almost everything. One example was we had a deal go to a board of directors and the board meeting ended and I called the CEO of the buyer and I said, how'd it go? And he said, not well, I got fired.
Oh.
So it's a lot of ups and downs, and one of our jobs is just to, keep calm. Usually we'll get some good alternatives in the end.
I agree, and in fact, I think probably all of us have been in this role. I'll say, I have really 2 roles on transactions. I'm a corporate M&A lawyer. I'm also a psychiatrist, right? Because there are many. I did a deal recently where very nice gentleman, great guy. He would call me every night around 10:30 for about a week, just be like, I don't know if I want to do this deal. And he was basically buying back his company from an ESOP. It was a real disaster. And he kept saying, I got this boat. It's beautiful in Marina. I should be on my boat. And I said, you should be. If you don't want to do the deal, don't do it. And he still did the deal because he's a glutton for punishment. But I think a lot of us are in that position where we will go through a deal and there will be multiple times where I'll get a call at 10:30 saying, can I just talk? Can I just kind of spend 30 minutes talking to you about, what I'm thinking. And I said, of course. And I don't bill for any of that. I don't have a medical license, so I can't bill you for any of that. So
Write that down.
yeah. But I think that's the right way to think about it, is that every deal is going to have ups and downs, bumps and bruises. And I think it's really important to have the right advisors who are kind of level-headed, who, if you are up high, they want to try to bring you back down. If you're really low, they want to bring you back up, right? I always say, don't get too crazy, even if the good stuff comes in, right? Nothing's real until the wires hit. So let's get to that.
I think it's important too is to have realistic expectations about the process, because clients will get excited and say, hey, I've got an LOI. So we're at the finish line, right?
We're done.
And that's really where the fun just begins.
Yeah.
Carson.
Yeah, I guess the question for maybe Dave and Eric is, what is the ideal time frame for you guys to start getting involved with a client? It might be different answers for both of you. And then when's like the latest realistically when you can get involved, right? When it's just like too late. It's just like, no, I don't know.
Can I add something to that, Carson?
Yeah.
Which is, there's a psychology also to going to, every one of you said 3 years, 5 years. That's a really interesting approach to somebody of, hey, you're gonna sell this in 3 to 5 years, that they have their act together that well enough in advance. And then to Carson's question, to have the confidence to engage you, how do you bridge that obvious thought we're all having of that conversation is awkward that far out?
Yeah, so I'll go first and I'll get myself. So one, the answer is always as early as possible. I know that's not realistic, right? Like nobody wants to go, because sometimes you don't even know when that 3 years is all of a sudden there, right? Sometimes life comes at you fast and all of a sudden you got to get ready for a process, right? So the way I think about it is there are a couple of critical milestones where you really got to get your M&A attorney in place. Look, I've been in situations where the LOI is signed, the first draft of the purchase agreement comes in, and then the client scrambles and looks to get an M&A attorney. And I think, and I'm just guessing, I think part of it is, I think a lot of clients are concerned about the cost, right? They're like, M&A lawyers are expensive. I don't want to hire one until I absolutely cannot wait another single day. And what I tell clients is, look, when we talk about the budget for a transaction, whether it's $300,000 for a lot of that, the vast majority basically come into play once we've got the LOI signed. And once it's signed, I mean, the chances of it closing, and maybe you can disagree, Eric, is probably 90%. Like I've had a couple deals that don't make it past the LOI stage. And usually there's a pretty good reason, right? One of them was like COVID. I had a deal die during the middle of COVID. Another one was, the owner had some really bad health issues and all of a sudden the company kind of went plummeted. But generally speaking, if you've got a signed LOI with a serious buyer and the banker knows the buyer, says, yep, they're in the space, they've done 6 deals in this space, there's a pretty good chance of it closing. And I always say, hire the M&A lawyer early. Even if I just say, look, I'm going to do very, very little until we have the LOI signed. That's okay, because at least I'm ready to go. I'm kind of shepherding the process at a high level. So I always say, look, as early as possible, but certainly before you get, start looking at LOIs, because there's always certain things I want to put in the LOI that you may not be able to get later in the game.
You're talking a preventative medicine attitude with people who are afraid to spend money because they're gonna feel that they spent it and won't get anything back.
Yeah.
And that is the challenge with an IB as well.
I think that's right.
Kind of kick that back.
And I think one of the lowest hanging fruits and the highest dollar per value gained is that if you've got a private business, it's probably an LLC or an S corp. I assume most people here probably have an LLC or an S corp. So if you get acquired by a buyer, what they're always going to do, if you have an S corp, they're going to convert you into an LLC because a private equity buyer cannot own an S corp. So when they do that, for tax purposes, even if you sign a stock purchase agreement, membership interest purchase agreement, for tax purposes, they're going to treat it as an asset sale. And if you treat something as an asset sale, a portion of the proceeds, it could be a little, could be a lot, depends on your business, will be treated as short-term capital gains, ordinary income, not long-term capital gains. And for some businesses, that can be a large whipsaw. So one of the lowest hanging fruits that I will always add into an LOI is that if they structure it as an asset sale, we will get a tax gross up where they will run the calculation, figure out what you would have gotten if you got all long-term capital gains, and the buyer will gross you up on the purchase price. That one little sentence could save you millions and millions and millions of dollars, right? And it doesn't cost me very much. I've got the foreign language, I throw it in there, it's one sentence, and that can get you, I've already paid for myself, right? So
I'm gonna answer the question, but then I'm also gonna throw it to Brad, because his piece is critically important. The vast majority of our deals, people come to us and they say, we're ready to sell. At that point, we can run a process, get to the finish line in 6 months, right? Sooner if they need to, but there's a cost to that. Usually the buyer knows that if there's if it's pressing, that there's a reason it's pressing. If we can get engaged 2 years ahead of time is a gift. It really is, because there's things that we just can't fix in the end. That, you know, that really will discourage buyers from ever showing up. So when that happens, it's super lucky. Now, the interesting thing with Brad is that we always try to bring in wealth managers, and the primary problem we have is what we call the jinx effect. The client doesn't want to jinx it. They don't want to think about what they're going to do with their money until they actually get their money. Try to talk them out of that. But Brad, I know that you need a certain amount of time to do effective tax planning. Can you comment on that?
Well, you actually made an introduction to me the other day, and it was sort of like, well, this business is probably going to sell in the next 6 months. They're interested now in talking about tax planning. There's very little that you can do in that regard when you have very little time. It's almost like, you know, you're going to run a marathon tomorrow when you reach out to try to find a running coach. There's just really not a lot of preparation. So effective tax planning often involves the creation of structures that have to be put in place. And we don't even know what those structures are going to be that are appropriate until we've actually done some diligence to understand and really have clarity around what the client's goals are. So I would say a minimum of at least a year is appropriate, but 3 years or 5 years gives us so much more optionality to try to figure out a plan that aligns best for them. And I agree with what you're saying. There is that jinx effect, but people need to really understand, looking out for their best interests, there's no harm in doing the planning. The more planning that they can do, the more prepared they will be, so that they will feel much less regret at the end of the day, and they'll be in a much better financial situation.
Rob, I don't know if this is you or Dave, but sure. I hear a lot of people, you know, tell you, oh, you got to get the QSBS, blah, blah, blah. Many of us who start our businesses at some point started them as S corp, started them not as C corp. Some people will tell you, oh no, you can't convert it. It's going to be this. Some people will tell you, no, you got to try to convert it immediately. How often are you trying to do these conversions before someone's going back to like tax planning before you sell? How, if you're not planning on selling tomorrow, how often is that part of the equation? Is we got to convert this to a C corp so we can get this QSBS down the road?
Well, as Dave said, if you're going to consider that possibility, you really need to give yourself 5 years. And it may not make sense to do it before that. So you got to have enough forethought to be able to consider that. Now, with the big, beautiful bill, it's a little bit different because 3 years gives you an opportunity to have some benefit from QSBS versus before it was just 5 years or nothing. Yeah. So there's some benefit there. And then, you know, I've talked to some sophisticated tax accountants that say that's not the only solution. If you have an S corp, there's some things that can be done using basis planning where you can swap basis of different assets. So sometimes they actually prefer that, would say, don't even try to go for QSBS if it's not appropriate for your business. Let's look at what other options. And from a wealth management standpoint, we can look at that too, to utilize structures or asset strategies that may be just as effective or very effective if that's not an option.
I think I agree with everything you're saying. And I also think that I always tell clients is don't let QSBS wag the dog, right? I mean, you still have a business you have to run, and maybe there's not necessarily the exit you're looking for at the end. So what I always say is, one, get your CPA to run some tax projections, right? That'll at least give you some numbers rather than just gut feelings of should I be an S corp or should I be in a C corp, right? Because there's definitely pluses and minuses for both. And you can convert. So we do a lot of conversions, right? So one of the strategies that we use for a lot of clients, especially if they are the type of client who is starting, like, for example, this is very common in the tech space where you could have a startup company and it's worth $1 billion, you know, down the line, right? Where the QSBS exclusion is incredibly valuable. And so what we will do is actually start it as an LLC. You kind of grow the business as an LLC. You don't cross the $75 million threshold, and then you get close to but not over. So it's kind of like Price is Right. Then you convert from the LLC to the C corp while it's under the $75 million threshold, and you get 10x your basis. And for tax purposes, your basis is basically based on the fair market value at the time of conversion. So you could potentially get, you know, $750 million of gain exclusion, right? I mean, that's real money. You could buy stuff with that. So the downside is your holding period doesn't start till the conversion. So there's a lot of decision trees that have to be made. We just went through this analysis with one of our clients, and he said, yeah, absolutely. I've got a long enough time horizon. It's his third or fourth business. He feels pretty good. And he's like, I think this business is either going to zero the next couple of years. Shocking, it's an AI company. He's like, it's either going to go to zero or it's going to go to $1 billion. unlikely anything in between, right? So we are going to use the strategy. I'm having a very similar conversation with another client who's running a new business, and he basically says, I don't think I'm ever going to sell this business. In fact, I think my grandkids will be running this business. I don't care about QSBS at all. I think this is going to be a nice cash flow business for the rest of my life and maybe my kids' life as well. So in that case, he said he did not care about QSBS. He doesn't want, he's going to get distributions and he wants a lot of distribution. So it's very much, I always say, don't let QSBS be the driver. Let your business be the driver, and then QSBS is a nice to have.
Can you touch on founder's brain a little bit more? From a founder's perspective, are you getting any pushback in terms of it being a little bit of too much of a window in terms of how they think and operate?
It's interesting. It's just getting off the ground. The folks who have tried it really like it, but that is the challenge, right? That you're really getting deep into somebody's business. The nice thing is these LLMs tend to be a little bit obsequious, so they'll tell you you're great, but it's really just getting off the ground. And I think these tools are only going to be helpful to us and to businesses in optimizing. So.
So I got a question. So if there's one thing a business owner can do today, if you know, and you can interpret that question however you want to interpret it, what is like a one thing? Like, this is really good value, right?
So on the long-term front, I would say by far the most important and yet the hardest is figure out where the industries you serve are going to be in 3 to 5 years. And if you don't think they're going to be healthy and thriving, then you have to start to think otherwise. That's really the thing, you know, longest out. And if you're talking more like a year, you need like a strong finance and accounting person to really help you not only get your financials in shape, but analyze them and figure out if you're as profitable as you should be.
So as I said, 50% of businesses sell involuntarily because the owners are not prepared for various reasons. So I would ask the question, what risks are you exposed to that you're not even considering? Because we don't want to consider those risks. You know, if any one of those 5 Ds, death, divorce, disability, disaster for the business disagreement happens, where does that leave your family? Because that's a real serious issue for a lot of people.
Great.
What's your answer?
All right, I'll cheat a little bit. So even though I'm a corporate attorney, I'm not a tax attorney. I think the number one thing that business owners can be doing is have a good estate planning attorney review all of your documents, right? Especially if you project yourself as having a taxable estate, you got to have that in place, right? Because the longer the timeline is and the earlier you get started, you can do like some even basic gifting, right? You do some gifting, you get it at a low valuation, use up some of your lifetime exemption at a really low valuation, put it in a trust for your kids or grandkids. You don't even have to have kids today, right? You can set up trusts for future kids you may never have, but get that out of your estate at a very, very, very low valuation. In an ideal, and you may have heard this advice from people like, you know, once there's an LOI, you can't do much on the valuation. Like, yeah, that's generally right, right? And not just that, some people think, well, I can just do it and then I'll gift it the day before and then I'll get the LOI. That's really risky, right? Like if you're going to tell the IRS, I got this valuation expert to come in and he said my business is worth $5. Then I do a bunch of gifting, and then the next day I get an LOI saying it's worth $50 million. You know, we'll fight for you, but you know, you're gonna have to pay us a lot of money. So the longer you can do it, when you don't, it's not even a glimmer in your eye, and you do the gifting, that's fantastic, right? What I always say is no M&A lawyer anywhere in the world, whether they're working at Cravat in New York or whether they're working here, nobody can get you the value that a good trusted estate attorney can get, because we're not going to get you 30% more of your purchase price. But even some real basic estate planning can get you as much of that or more, right? So I think it's absolutely critical to have good tax planning early in the process. It's the one thing I would always do.
Do we leave it there?
All right, that's it.
Thanks, guys.
All right, thank you so much.
We've got people in the back and please go.
Dave, that's great. Everything I heard is call you at 10:30.
Yeah, please.